The court will call CR 2025-177, State of Arizona versus Richard Baptiste.
Good morning, Your Honor. Brad Roach, Lacey Collins, and Conrad Findley for the state.
Thank you.
On behalf of Mr. Baptiste, who's present in custody, Judge, if you could join me. And Judge, while he is coming up, also would like to know Colleen Place, present via Teams as victim's representative.
All right, thank you. Ms. Place is noted.
Good morning, Your Honor.
Good morning. It's Mr. Roach, Ms. Collins.
Yes, Your Honor.
Thank you. Mr. Brewer, counsel for the defendant, is present. The defendant present in custody, come up to counsel table now. We are set right now for both a preliminary hearing as well as a proof evident presumptive great hearing regarding release conditions. Mr. Brewer, how would your client like to proceed today?
Judge, I'm not going to speak for the state, but my understanding is they're not going to go forward with the proof evident presumption great hearing. They're just going to ask for a bond. And I'd like to be heard on that, obviously, but I don't have an objection to not doing a proof evident presumption great hearing. With regard to the prelim, we're still a little light on discovery, and I'd like to have a little more before I'm comfortable proceeding. We would like it to be set for a contested. As far as time frames, I guess that's just, we'll have to figure all that out. The other concern I have, Judge, or the issue, right now I believe these cases are severed. Is that correct?
As I understand, I think they're two completely separate cases.
Okay. Then that may make it a little easier to set things up for a hearing, but yeah, that would be the next step. And again, I don't know if the state has a gauge as far as how long a bulk of this disclosure is going to be provided, but I would like to at least have that before we go forward, as well as some time to digest all that information. We're gonna be waiving time, at least for the time for a preliminary hearing, so we can have that. But we certainly would like to have discovery provided as soon as possible.
All right, thank you. And Mr. Roach, on those issues and others you need to address, go ahead.
Thank you, Your Honor. Yes, we are not going to be asking for a proof evident presumption great hearing today. We are going to be asking to argue about the bond. We have been continuing in trying to get disclosure out as quickly as possible. Of great importance in this case was about 140 pages of hospital records that were disclosed this morning. We tried to get those as quickly as possible, but getting out of Phoenix Children's Hospital, there's going to be quite a great amount of disclosure. So we're working with detectives to get everything out as quickly as possible, and we will roll it out ongoing. We would also ask for a preliminary hearing date. Judge, and I think we'll be filing a motion to join the two cases because the evidence that we have, we believe would be pretty much 100% identical for both of them. So I don't know if the court wants to consider that. Well, we'll file it, and so when picking a PH, it would, I think, make more sense if we had the PH for both at the same time, but obviously that would depend on the court's decision on joinder.
All right. I just state on that, I understand the position of the parties just listed, although right now they aren't joined, at least as far as and I'm a little bit late to catching up on everything. I don't believe anything's been filed or addressed by the court or the parties regarding joinder, just based on, and I think ultimately that would have to do with our trial dates for the courts and court's convenience, and especially for efficiency, that I think would serve all of the parties and the public's interest. My intention would be that if both parties would be requesting a preliminary hearing and or a proof evident presumptive great hearing, I would plan to hold those together at the same time, because I believe, on the very little information I have, that the information, witnesses, etc., would be similar or the exact same for those kinds of hearings. So just in the interest of judicial economy, interests of the public and victims, as well as the defendants, my intention would be to hold those together, assuming both parties are requesting those, and I haven't addressed Mr. Lee or his counsel yet. Regarding Mr. Baptiste's request, and it sounds like it's joined by the state, I'll vacate today's proof evident presumption great hearing. We will address bond issues before we wrap up on this matter, but also the request to set a contested preliminary hearing. I believe both parties in Mr. Baptiste's matter agreed that that would be appropriate. I know we haven't heard from possible co-defendant yet regarding those issues. I may have Mr. Lee just interject a little bit on that issue as we go forward. Mr. Lee, and I am addressing Mr. Lee, who is counsel for Anicia Woods, CR 2025-178. I don't think you heard all of what counsel addressed here, but regarding a preliminary hearing, what I understand, though we don't have a date, is that both the defense and the state are requesting that a contested preliminary hearing date be set.
Our request as well.
All right. So we'll address those right now. Mr. Brewer, from your perspective first, how long do you think, I know it's tough to gauge and disclosure is like drinking from a fire hose when it comes, and you can't control when it comes. How far out do you think would be effective to look at right now?
Judge, and I guess I have one other thing before I can really answer that.
Okay.
I'm not super excited about doing a motion to join. I don't disagree with the court's assessment of doing them together. I think that makes judicial economy. I'm not agreeing that that's a joinder, and I don't think that's what the court was saying. But I would rather go in that fashion until we have a lot more information. I mean, the state can file whatever they're going to file for a motion to join, but I'm not going to be able to file a response until I see the statements that were made and things of all that to see whether I have a challenge that I can make based on that. So, but I think probably 30 days for a prelim would probably be appropriate.
All right. And Mr. Roach, regarding timing, does 30 days out approximately seem appropriate for dates to look?
Yes, Judge, we were hoping for 2 weeks, but I do understand the volume of disclosure in this case is going to be significant.
All right. And we definitely can look at those dates and then talk. And then, Mr. Lee, from your perspective, just as far as timing for a preliminary hearing, approximately 2 weeks or a month look most appropriate to you?
That's fine, Judge. Did you want my client out here?
I think we'll probably call her separate, although I know a lot of the issues that be some duplication, but we'll try to address all but the dates a little bit separately. There are, and Mr. Roach, I know it's a hard, probably a moving target at this point. Do you have any estimation as far as a time that would be needed to hold a preliminary hearing in this matter?
Judge, our presentation is going to be relatively short, surprisingly short, given the charges. So we would take probably 30 minutes.
Okay. And Mr. Brewer, Mr. Lee, as of right now, do you expect needing more, Mr. Roach asking for a half hour, needing more than an additional half hour for any presentation that you might choose to do at that preliminary hearing?
Judge, it's very hard to gauge. I mean, I assume my cross will be probably at least half hour. I'd probably ask for more like an hour on top of that, so just to be safe. Any offer of proof, however, it would probably have to be done at a separate time if we had one and if the court accepted that. But other than that, I don't have anything to add.
All right. Mr. Lee, on timing.
I agree. If you're doing them together, you can meet your half hour.
All right. So I'll probably set aside, to be safe, a 2-hour window. There is a white sheet on the corner of the table there. That is my general availability right now, primarily focused on Wednesdays and Thursdays. I know counsel, some or many of you will be traveling. Do those days work in general, Wednesdays and Thursdays during the week?
Judge, the September 4th would work well for the state.
2nd or 4th?
The 4th, please.
Judge, that can work if we can do that in the morning. I have an afternoon matter in Navajo County I have to do, but I could get there if we did that at like 9.
Mr. Lee, Thursday, September 4th? All right. So
Judge, could we check with Ms. Place?
Oh, yes, thank you. Apologize, Ms. Clace. Regarding that date and time, September 4th in the morning, would that work for you?
That works, Your Honor. Thank you.
And just so I clarify, I've talked to court staff, but I don't have all of the details yet, haven't reviewed all the documents. Ms. Clace, is she appearing, are you appearing on behalf of victims in the criminal cases?
Yes, Your Honor. I've been appointed under 134403 as the victim representative for the deceased victim and the two younger siblings.
All right. Thank you for that clarification. I thought, but wanted to make sure regarding that. Apologize for overlooking you in addressing these dates.
Thank you.
With that, we will set right now, and then we'll address this issue and the other matter. Contested preliminary hearing in Mr. Baptiste's case for Thursday, September the 4th. I'm going to set aside from 10 o'clock a.m. until noon. The parties don't need to, of course, fill all of that time, but we will set it aside as it's necessary for that hearing. We will address Ms. Wood's case. My intention is, although I'll hear from the parties, setting that same date and time for preliminary hearing in her matter after hearing briefly from Mr. Lee. Mr. Brewer, regarding the preliminary hearing, I will note that you waived time on behalf of your client for the purposes of the preliminary hearing. Time limits. And then I believe we, of course, need to address bond issues. And I will clarify, I'm not sure how clear I made it before. I'm not ruling on any motions to join or anything right now. I don't believe any have been filed as of now, but just stated my intention that if both defendants decide to go forward with a preliminary hearing, and it's at all possible from the court's perspective, that we would try to join those at the same date and time, not legally join for trial purposes at that time. Mr. Brewer, regarding, I guess it's actually the state's motion regarding bond amount in this matter, Mr. Roach, what would you like to address with the court?
Judge, I would ask that a substantial bond is necessary in this case, both to protect the public, the victims in this case, and to ensure the attendance of the defendants in all future hearings. I have marked, if for the court's consideration, exhibits 2, 3, and 4, which are excerpts from some of the hospital records regarding Rebekah, the victim who died, indicating both acute, so some very recent significant injuries that she sustained, subdural hematomas, bruising up and down her entire body, missing toenails, and then also long-term care issues, severe dehydration, severe malnutrition that was not acute. So over a long period of time, this child was subjected to some horrendous conditions that eventually caused her death. The Phoenix Children's Hospital doctor in Exhibit 4, Dr. Hubbard, in an actual medical diagnosis said that the above findings are highly concerning for child physical abuse, child sexual abuse, and torture, which is a surprisingly shockingly strong word for a medical doctor to put into a medical report, especially someone from the Phoenix Children's Hospital that sees a lot of cases where children have had problems. For those reasons, we believe that the safety of the community is at risk, the safety of these individual children, the children that are alive, at risk, and then we would also suggest that the nature of both the homicide charge and we're going to also have several DCAC charges, dangerous crimes against children charges, which obviously must run consecutive to any other sentence would invite anyone to attempt to flee the jurisdiction based on the sentencing that's looking forward to. Rebekah has a lot of injuries, but it's important to note that Colden and Caleb also have very significant bruising all over their body from apparently either belt or some other injuries, including genital injuries that are very concerning. So for that reason, we would ask for $1 million bond.
And you mentioned the 3 victims, the latter 2 victims you mentioned are in reference to count 5 and count 6 of the complaint. Is that correct?
An amended complaint that doesn't allege any, or I don't think it alleges allegations against other children. I reviewed it very quickly. It may have, but there's only 3 counts. Those are in there.
I am looking at the complaint. I thought it was an amended complaint, but I could be wrong. Filed July the 30th. Is that the most recent?
We filed an amended complaint this morning, Your Honor.
This morning. All right. I apologize. I have not seen that. And does that one have just 1 victim or 3 victims?
All 3 victims.
All right. Regarding the latter 2 victims that you addressed, were there multiple counts or 1 count of child abuse? What was the status of that?
So right now, because we have so much medical information incoming, we have selected to charge just 1 count each of Class 2 child abuse, which is intentionally or knowingly placing the children in a situation where death or serious physical injury could occur.
All right.
I expect that the evidence will indicate a number of other charges for all the witnesses or for all the victims, but because it is so complex, we're just going on those 3 charges at this time.
All right. And Mr. Brewer, as far as the amended complaint that's been filed today, have you seen that yet?
Judge, I knew it was filed and I misspoke because I didn't review it clear enough. So yeah, I'll retract that issue with regard to the other victims not being.
All right. Regarding your position on appropriate bond amount, go ahead, Mr. Brewer.
Judge, it's, again, it's very early and it's hard to assess all the information that's been provided in a quick time frame. But as far as the rule is concerned, he is presumed innocent. Release is presumed unless the state can demonstrate just sufficient basis to prove otherwise. Obviously, the charges are very serious. There's no question about that. I'm not aware of any criminal history of Mr. Baptiste. I'm not aware of any kind of failure to appears, nor did the state mention anything like that in their recitation to the court. I think those are important things to consider when determining whether or not someone is going to return. It doesn't appear that there's any suggestion that in the past Mr. Baptiste has not abided by court orders when told to, or just hasn't had to abide by court orders because he hasn't been in that situation. And I think that's positive. He's lived in Arizona since he was 12, recently in Apache County, but he has lived in Arizona since he was 12. And as far as the public safety, concern, from my perspective, and I think from the facts of the case, there's not a suggestion that he is doing this to other people. If the allegation is where they're saying it is, it's directed at these children, which of course we deny. But I mean that's the situation. I don't think there's any suggestion that he is a danger to society were he to be released. He's also not a danger to the children in this case, Judge. They are in DCS custody. There's no way in the world we're going to have contact information. There's not going to be any kind of contact he's going to have with the children, nor is he going to have any kind of information as to their whereabouts. And so I can be pretty certain that there wouldn't be any chance that there would be any harm or potential harm coming were Mr. Baptiste to be released. So I think that's something the court can consider with regard to the release conditions. Obviously, Mr. Baptiste is appointed counsel. He's indigent. I mean, $10,000 bond, $1 million bond, probably not going to make much of a difference with regard to whether or not Mr. Baptiste gets out. But I think that, the $1 million bond certainly makes a statement, certainly says, oh, we're serious about this charge. But is it consistent with, Mr. Baptiste and his ability to make the bond? I mean, I don't think it is. I think that, if there's a bond that's required, it should be much, much lower. It doesn't seem that it's going to make a whole lot of difference whether it's, like I said, 10 grand or $1 million. As far as him fleeing the jurisdiction because of the charges. Obviously, I think that's the state's strongest argument with regard to whether or not Mr. Baptiste will return. But all I have to show for that is, again, that he has appeared when he's supposed to, or has not appeared when he's supposed to. And I think that is important in determining whether or not an individual should be released or should have a lower bond. So I would ask for the court to consider if a bond is necessary, if the court believes that OR release is not sufficient to secure his attendance in future proceedings, that the court would impose a bond that is reasonable under the circumstances, reasonable given his indigent status, and impose that. Other than that, Judge, I don't have anything to add. Thank you.
All right, thank you. Ms. Cleese, yes, I was coming to you, your position regarding the bond.
Yes, Your Honor. I had hoped that the defendant would remain non-bondable, but I would also ask that the court set a $1 million bond.
All right, thank you. Anything additional to add, Ms. Cleese?
No, Your Honor. Thank you.
The court will note that regarding the purposes of bond in the matter, those are to assure the appearance of the accused, to protect against the intimidation of witnesses, to protect the safety of the victim or victims and any other person or the community. Based upon the documents as well as the arguments of counsel today, the court has considered the views of the victim representative, the nature and circumstances of the offenses charged. I don't have information right now regarding the weight of the evidence against the accused, except as it was addressed by the exhibits proposed by the state, and I have not reviewed those. I should take a step back there. Mr. Brewer, any objection to the court for the purposes of just the bail, considering I believe it was state's exhibits 2 through 4?
Yes, sir.
Judge, I mean, it's hearsay and has a lot of stuff in there that's probably not admissible, but this is not a hearing that probably requires all the evidentiary rigors as other hearings may have. I'll just lodge an objection based on that, but yeah.
All right. Mr. Brewer's objection is noted, but the court will admit the exhibits, state's exhibits 2, 3, and 4, just for the purposes of our bail determination hearing today. And is Ms. Curtis right there? I can't see.
No.
Has pretrial services made any determination in this matter? Do we know?
I don't know. I can make a phone call.
That's all right. I'll just review the file as it exists right now. Thank you.
Your Honor, this is Roxanne at probation.
Yes, go ahead.
Pre-trial, let me know that if they are released for or he's released for pre-trial, it would be level 4 with a GPS monitor.
All right. And regarding, do you know if a release assessment or anything was completed?
That I do not know. I was just told that would be the level if
All
that
right.
became the case.
All right. Thank you. And Mr. Brewer, or I apologize. Mr. Roach, are either of you aware of a completed assessment regarding release conditions?
I'm not sure.
I haven't received any.
All right. I don't see one in the file. If it did exist, I would need to review that as well. Mr. Brewer has provided some information for the court regarding residence, time of residence, his awareness of history, or flight or lack of history or flight from prosecution in the past. I have also reviewed briefly and considered the Apache County, Arizona bond schedule guidance provided for all of the judges in the court, not as any kind of controlling direction, but as direction in cases when considering an appropriate bond. Just going to review very briefly on the record State's Exhibits 2, 3, and 4. Based upon all of those considerations, I will set bond in Mr. Baptiste's case in the amount of $1 million. That could be a secured appearance bond. We have set the additional preliminary hearing date. Mr. Brewer, anything additional we need to address today regarding your client?
Yeah, just I guess, my client doesn't have his glasses, and he needs those to be able to function. I just asked if they can be released. I'm not sure what the glasses requirements are in the jail, but that could probably be pretty frustrating, not being able to see while he's doing stuff in the jail. And so I would just ask that they release the glasses to him, make sure there are no issues with them, and then other than that, Judge, I don't have anything else. Thank you. All
right. To your knowledge, were those taken by law enforcement or by the jail?
I was.
Apparently, Judge, they were just going to do a check on the glasses first and then give them. So I can't. I assume it's the jail because they would be the ones checking, but.
All right.
I can't say for certain on that.
Mr. Roach, any information and/or position regarding that request? And Mr. Brewer, do you know, are those needed? I'm sure they're needed for many things, but does that include the ability to read, or are they for other items?
That's the primary concern, Judge.
All right.
I think the glasses that he had when he was taken into custody were taken with his clothes and put into evidence. So that's where they are now.
All right. And I'm sure there's little information regarding that right now. Mr. Roach, I think I would just order the state to assess whether or not those were intentionally taken as evidence and have any evidentiary value. If not, I would ask for an expedited as possible release of those through the jail to the defendant, Mr. Baptiste. If your determination is that they may be irrelevant as evidence and need to be kept by the state, please inform Mr. Brewer as soon as you can regarding that. And then I will just have another, not specific order now, but for the jail staff to review and confirm whether it might be medically necessary to provide glasses to him. We'll kind of address both of those routes so that hopefully one way or the other, Mr. Baptiste has the ability to receive those glasses that I've told are necessary for reading, which would be necessary in moving forward in this case as quickly and expeditiously as possible.
Yes, sir.
Mr. Roach, any additional issues you need to address in this matter today?
No, thank you.
Ms. Clace, anything additional from you for today?
No, Your Honor. Thank you.
All right. And I thank all those who have been present We will adjourn in Mr. Baptiste's case, and I will call Miss Woods in just one moment and have her step up. Thank you. We'll be adjourned in that case.
Thank you, gentlemen.
Thank you, Mr. Brewer. Mr. Roach, Ms. Collins, same appearances in this matter?
Yes, Your Honor.
Yes, Your Honor.
All right. The court will note the appearance on behalf of the state of Mr. Roach, Ms. Collins, Mr. Friedley from the county attorney's office, also the presence of our county attorney here today, along with others witnesses. Note the presence of Ms. Clace, victim representative present, Mr. Lee, counsel for the defendant, and the defendant, Ms. Anicia Woods. Is that correct? Ms. Anicia Woods is present in custody with counsel here today. As noted previously, we were set for a preliminary hearing and proof evident presumption great hearing regarding conditions of release. I took a short opportunity to speak with Mr. Woods during our Mr. Lee during our last hearing regarding Ms. Woods. Mr. Lee, we have set a contested preliminary hearing date on Thursday, September the 4th at 10 o'clock. Would that date continue to work for you and your client regarding a preliminary hearing in this matter?
That'll be fine, Judge.
And regarding that specifically, Mr. Lee, any problem with waiving time for the preliminary hearing until that date?
No, sir.
So the court will, and counsel for the state, nothing additional regarding the setting of that date in this matter?
Correct.
All right. Ms. Clace, anything additional regarding the preliminary hearing date and time in this matter?
No, Your Honor. Thank you.
So court will order that Ms. Woods' case will be set for a contested preliminary hearing Thursday, September the 4th at 10 o'clock a.m., set aside until the noon hour for that hearing. It will be set at the same time as Mr. Baptiste's hearing, but the court has not ruled on any and is not aware of any current motions to join for trial. But in the interests of all of the parties, the court, the public, and efficiency, those will be set at the same date and time. If they go forward with one or the other or both, we'll plan to take care of those that day. Other than that, Mr. Lee, what issues do you need to address for today?
Well, we just heard the court's determination of the bond in the last case, and I don't see anything different. My client's had no criminal convictions of any kind. It's her first contact with law enforcement. She's not run from any court. She's all of the same stuff Mr. Brewer said applies in this case, and I don't know if the court consideration is any different. So,
all right, and is it your understanding that I'll ask the state that they not going forward with a request for no bond, that will be setting a bond today?
That was my understanding, that they backed off that motion.
All right. Mr. Lee, just one or two little clarifications if you can, or if you wish to. What is the relationship between Ms. Woods and Mr. Baptiste? And if there is any relationship between Ms. Woods and the alleged victims in the matter?
I think they plan to be married, and the children involved here were all his from another relationship.
All right, no blood relationship between her and the alleged victims?
No.
All right. Mr. Roach, regarding the no bond or getting rid of the no bond request and bond issues, go ahead.
Judge, a similar argument as I had. The only thing that I would add in this particular case is, as the court noted, Ms. Woods is not biologically the mother of these three children. However, for the last 4 years, she has been acting as the mother. The biological mother has not been involved. So she has been the mother that these children have known. And this is not a case where the evidence indicates that one parent is more involved in the state's allegation of abuse. In her interview with the police, she admits to hitting the child with the children with various implements, causing injuries to them, including, as I discussed, toenails that had been torn off and hair that had been pulled out, things like that, this defendant admitted to participating in also. So it is not a case where, from the evidence that the state is aware of, one of the two parties is more heavily culpable. They appear to be equally culpable, and we would ask for the same bond.
All right. Ms. Clace, regarding bond release issues, anything that you would like to address, and you don't have to readdress any that you previously did, I will take those under consideration already. Go ahead.
Yes, Your Honor. My request would be the same for the co-defendant, no less than $1 million.
All right. Thank you. I will briefly note, and Mr. Roach, I will get it. Mr. Roach, regarding State's Exhibits 2 through 4, would you like those to be considered in this matter as well?
Yes, Judge. Thank you for clarifying.
And Mr. Lee, any objection to the court's consideration? They were 3 documents from medical related to treatment of the victim.
I have those documents, Judge. And it says this whole proceeding is to find out how that happened. I don't know why the court's considering it, but okay.
All right. I'll note Mr. Lee's objection. I will admit those as State's Exhibits 2 through 4. And if we don't have, we'll get an extra copy of those so they can be filed in this matter as well, just for the purposes of this release conditions hearing. My review of Ms. Wood's file similarly did not show any assessment that has been completed. It may have been, but it isn't brought to the court's attention at this time. I considered the same purposes of bail or bond in the case and made all of the considerations under the rules and statutes required when considering bail, particularly the victim's position through counsel and victim representative, as well as the threats and dangers and harms to the victims, as well as to the community. Based upon all of those considerations, the court will set bond in this case in the amount of $1 million secured appearance bond. Ms. Woods, if you do bond out in the case, you are still under the orders of the court, including a requirement that you would engage in pretrial services. So if you get to the point of bonding out, you still have some requirements to the court. Most important among those are to show up for all of your hearings, stay in touch with your attorney, and obey all laws. Mr. Lee, anything additional we need to address in this matter today?
No, sir.
Mr. Roach?
No, thank you.
Ms. Clace, anything additional from you?
No, Your Honor. Thank you.
All right. Thank you all. We'll be adjourned in this matter.
Thank you, Your Honor.
Thank you.